Welcome back to another RFP Rapid Fire podcast. I'm Matt Hutchinson. I'm back in the great city of New York City, where my company actually started here, and we still have our offices here. I'm also with Jerry Keogh, who's also in New York City, and Sabi Ghosh, of course, from Pune, India. And we have a great discussion that we've been having, over the last couple of days, months, and weeks about AI and the all that legality that comes with AI, whether it's how it's being regulated, what ownership as creators or developers do you have when using AI generation, when using AI code, where do we lay right now? What is the reality of that? And we have a really interesting discussion because what just came out recently in Europe with the GDPR is that if your AI product does touch someone in Europe, you're on the hook. And it seems to me that really, if your AI is global, your legal risk is global too. And for someone that is a digital developer and we create a lot of AI content, that is a concern for people that are looking to either sell some of that content, sell some of that what was AI generated. And then for people that are vibe coders, I mean, a massive question mark right now. So I want to bring in Jerry you first because obviously you're a great legal mind, and I want to get your perspective on what the GDPR really just announced here and how it's really concerning for people that are in the AI space because all that value you get from being able to generate with AI and create with AI and develop with AI, it seems to me it's like we're kind of maybe we took a few steps back here. If you could just explain that to our audience.
Yeah, thanks, Mac. Always great to be here on the Author's Corner. We learned so much with your great publishing company and your innovative approach of editing, which is very different from traditional publishing houses, bringing actual authors who are also skilled in the art or in the trade. And in this case, you've got a significant amount of legal minds that are writing books for your publishing house. So this editing session that we do every Thursday, love it. Look forward to it. How this all sort of popped up really was triggered by two things. One is the EU AI Act that is basically mandating very strict transparency for what's called synthetic content. And so if I'm a prompt engineer and I work for, or one of your digital artists, you're very brilliant digital artists, you're working away, you have clearly architectural background, you got the artist background, you've got, now you're constructing a site like you're building a site for a presentation or for a movie or for a short clip, and you want to set the stage. I see this all the time when we're doing regular podcasts. We just did a couple of them on the road when we were in Quebec City. I saw how you meticulously set up so you can capture the artistic presentation. Now, when you do all of that and you reduce it to a writing, so you have a very legitimate, bona fide writing. That's the prompt engineering. Now, the picture that comes from that is frankly so embedded into your prompts. This is not just like put a hat on this guy and make him Santa Claus. This is like, God, this is a true example of garbage with data, which our data king can tell you, garbage in, garbage out. So the EU AI Act wants that say that if you're going to present anything, and it has an accessibility to Europe, which meaning that you basically are not blocking Europe out. Then we want this content, and they're now going to enforce it for the first time, that you have a mandatory strict and a very strict, it's just strict liability transparency for synthetic content. Now, you have a very unique scenario where you take a lot of your own photos and then you meld those into some of the artistic designs that you do, and then the AI kind of generates that. That's still because you're doing that, even though like 90% of that art presentation is yours, you still should. I think the best way to handle it is just a watermark on it that AI was utilized in this, so that the end user has it. And we've been using that a lot anyway in the and well, not we, but MGSN's been using it, where they're putting out
Hmm.
disclosures saying this picture was generated by the artist at TIL Academy, who sat down and interviewed with us. In my own book that I have an epic cross examination, which I worked with you guys on, where there's it's the Socrates, the issue of what happens when courts become corrupt. And is there a correlation between violent upheavals and corrupt courts? And that what one of the things, the why Socrates was received the death penalty in the Athenian courts, was he was calling into mind that he felt that the courts in Athens were corrupt, and were corrupt by the monies that be. And at the end of the day, I had a picture that we worked so hard at, where Miletus,
Hmm.
who is the charger, was being cross-examined by Socrates, but instead of that erudite manner of just exchanging philosophical debates, I turned that into a hardcore Brooklyn pugnacious courtroom, where people get in your face, and the jurors and the judge, everybody expects that this is the true dialectic, the clash of the opposite ideas, and this is New York City, so people are going to express themselves in a very sort of pugnacious nature, and that's what we captured on that. Now the question comes down to is, we put a full disclosure on that. Is that now under challenge because of a couple of things? Well, first off, the GDPR Article 3, what that basically establishes is that as a data point, the likeness of facial features that could put a company like you at risk, and saying, wait a minute, hold on a second, that's me. I'm sitting here in a kitchen in Finland, and under that GDPR Article 3, and Sabi will get more into why that's a data and what your obligations are, irrespective of an AI claim that I can't, infeasibility, I can't do that. That's not going to wash on the GDPR. But I'll let Sabi, he's much more, he is the data king. The real problem that you really have is the Thaler versus Promoter Cut. The Supreme Court very
Yeah.
disappointedly failed to accept cert on that case. That case basically takes out of the component the U.S. copyright protection, not only for the picture, the generated picture, which I'm okay with that, but the prompt engineering, they basically denigrated that, and the Supreme Court, by its inaction, has accepted as the law of the land that prompt engineering is not an individual right or a copyright, even though it's words, it's artistic words, it's industrial words. These are all words that are put together. Again, I'm not talking about hey, here's a funny picture of me walking in Disneyland, where that's crap in, crap out. This is a much more difficult position that the Thaler case have. Now, we had on the author's current corner, but he had to go for other discussions, Pankaj Jain. And Pankaj Jain, in his book, actually analyzes the Thaler case. It's because it's going to have reverberations. It's going to have reverberations. For example, if Congress changes, I think a lot of the creative community is going to come out and say, wait a minute, you're going to have to do something and pass a law
Mm.
here that recognizes our rights. Our rights. They were stripped away by the Thaler court, and the unfortunate refusal to cert on the U.S. Supreme Court. So these
Yeah.
issue is not dead. The question is, it's shown the fight really has just begun, because creative
Hmm.
people like you who are coming up, and then what is then the purpose of generated AI? What's the purpose of the LLM? You're going to say, well, it's a fun tool. Okay, then market it as a tool, but that's not the way you're marketing it. You're
Yep.
marketing it that, hey, if you're a digital development company like Mac Hutchinson's company, you can save a lot on operational expenses, and more importantly, you can cut down the cost of production by utilizing these great AI tools. So
It's
that's
very
going to be an
frustrating.
issue too.
It's very frustrating, especially for startups that are under that idea of, okay, you can now build a start. I mean, there's look at that incredible company Lovable that's gotten $1 billion of funding, that's looking to help people build their prototypes. I mean, these things are all in question now because the law doesn't the law doesn't stop at the borders. I mean, the GDPR is the law of the land right now, and you're now at legal risk here if you're using AI to help you generate, whether that's images, videos, or even code. And I think this is a massive development that people aren't talking about. And I want to thank MGSN for covering this, and of course all of you guys, great legal minds, talking about this because Pankaj did. We'll definitely have him on the next RFP because he does lay out that very simply that okay, this is the law of the land, and right now, okay, you can't really claim ownership, and we're in that starting point right now where there's a lot more that needs to happen, and I want to bring in Sabi Ghosh because Sabi, you are the data king, like Jerry just said, and right now, I mean, if the GDPR is saying, "Hey, people can now ask companies to delete their data," these AI companies, I think, would probably turn around right now and say, well, that AI doesn't work like that. And so you have a law now that's telling them, hey, delete the data. And AI is kind of saying, I don't know how to. If you're a company right now and you're someone that is an expert in data with AI influencing that, where do you go from here? What is your understanding of this position?
Thanks, Mac. Thanks, Jerry. Thank you for inviting me. I believe that it depends on the data collection to start with. If the data is legally acquired data, and that
Mm-hmm.
means from scraping the public sites, licensed database, then we have the right to fair use the data. But if the data is nothing but a pirated data sets, then I think the problem comes to play. So with the pirated data sets, neither we can have any right on that, nor we can, and secondly, we can be hauled up by the owner of those data. But if we have legally acquired, say it's a part of our business with a data company, and we have an agreement to use their data, to process their data, to exchange their data, then there will be no problem as so far as data is concerned. So far as Europe is concerned, the need is not much different from what I said. So what we try to do here is that there is something called from March 2026, there is a transparency, mandatory transparency is required in case somebody is dealing with data in the EU. So the developer may soon be required to disclose all copyrighted data to a public authority called EU IPO and potentially pay a flat rate copyright fee to compensate the creator, meaning thereby that if the data is obtained from a legally acquired database or data owners, then I think we have a right to fair use the data. Against if it is a pirated data set, which we generally get on AI agents, that we need to be very careful using such data. Mac.
Yeah, and Sabi, I really appreciate that because I'm looking at all these companies now that, or even for creators or developers, say they're starting to vibe code, right? You have these record numbers of people that are going to Anthropic and Claude and using Claude code and using all these different AI tools to help build their prototype or build their app or build their website. What if it comes out that, maybe a company uh, was using copyright data or is using someone's code? Like, do all those things that were generated at that certain date on top of that are now in question? I mean, I think for people, this definitely is a part. This is now where they start to question a few things. And for people that think that, this GDPR doesn't seem global. Well, people have to understand AI is global. We're in a global world now. This isn't confined to Europe or this isn't confined to the US or anyone in the US. So laws like Article 3 of the GDPR influence all of this, all these companies outside of its borders. And we're really trying to figure out this power structure and where we all fit.
I believe the state is very fluid at this point of time. And
Mhm.
very soon, I think even in the US as well as in the EU, if the pirated data are presented, then I think we need to present it before an authority and pay the potential for copyright fee to compensate the person if there is some owner. So this is important, that whether, as I said before, that it's an instruction versus expression. So if we are using the data available with us in a manner which shows that the data were only available to us, but we have not violated the copyright of that person, we have reused the matter, reused the data, we have remodeled the data, we have used the data in a manner that data cannot be called a copyrighted data, then we are the owner. But if we directly take it as a given instruction to the AI, give me this data of how many people have born in US, in the state of New York last year, then this is a government data. So then the person who is using the data is not the owner of the data. But the I think the field is very fluid, and in the coming days, I believe lot of development are going to be seen, or in EU as well as in the USA, in this particular case, which would be copyright violation vis-a-vis AI, vis-a-vis right to publish, right to privacy, in this way, and how the Senate is reacting to it, because senators are more or less, they are all corporate people, and if there are corporate people, they are having a AI based their infrastructure business. How the business is going to flourish if those AI oriented products cannot be copyrighted? So it would be a battle also between the senators as well as the copyright house in the USA. And so these are going to happen. But as the things today, we need to be very careful. To proceed, if we are working with the data, or any such documents which are in the public forum.
Yeah, that's great stuff, Bobby. I mean, this is a great conversation. I mean, I'm so glad for our audience they're able in this author's corners get the insight from the Data King, Sabi Ghosh himself, and then of course the great legal mind. You've got Jerry Keogh, who's worked with countless of global transactions and global developments over his time as an attorney. Jerry, I want to get just now that Sabi's just spit that out for us, this really conversation is about who's controlling AI right now. Do you got any last and final words on this before we wrap up?
Yeah, if I'm a young company like yours, and I solicit out for companies who want websites, they want some imagery. Fortunately, because the way your company is structured, but if I'm in this field, I would do very similar. You got a great GCC and a great relationship, and your weekly Monday meetings with the GCC is really key. And I think one of the things that you're probably going to want to study, because at the end of the day, you don't want to be in a situation where the AI companies are out there saying, "Hey, listen, you come to and go to a pro level, you'll own your prompts, you'll own the pictures, you'll own the codes." Well, they don't say that you own the pictures anymore, but you'll own. They definitely say you own the code. Now, we don't know how that vibe coding. Did it come from an open source, or did it not come from an open source? So the real question comes down to is, if you get a code, then you want to sort of get that code run through a GCC like you have, and then you want to have somebody like yourself who's been behind the creative side of it, make sure that there's a coder sitting there in your office in Pune who is adjusting the code to make the code yours. That's one component of it. The other issue with respect to the pictures, well, if I'm going to be retaining a company to run my social media, then they're going to have to pay for the pictures. You're going to have to, now the pictures should all be internal, and where you can use the AI from the name, image, and likeness is not going to be a key if I'm in a public space. So we talked about this example before, where you take a picture as an artist. You do this a lot, Mac. You take pictures, and you have people take pictures of a really nice sunset. That sunset could be in Pune, India. Then you're on one of the things that one of the pictures that we have wrestled with Gerard McCabe's book, which was picked up by the Data King himself, knowing what the GDPR stated. Said, look, you might be able to get past copyright on this because Pankaj is correct, you know. But conversely speaking, what if you're some individual who's sitting in London, or you're in Finland, and you say, wait a minute, that lawyer who's now got a advertisement for an LPO firm on the satchel that she's covering, that's me. That's me. They somehow took that off. Look, here's a website of me graduating from school here in London or wherever. And so I'm now going to file a complaint, and under you say, well, wait a minute, this was made in India, in Pune. It was commissioned in the United States. You got nothing to do with it. That's not what the law is. But in your particular case, if you were to take the magnificent sunshine and that acts as a filter, filtering out any sort of facial recognitions, and then you reposition there so that the facial recognitions are protected and compliant, that's going to be the challenge there. But I think companies are going to have to realize that especially if they're based in the United States, that they're not going to get any protection from the U.S. Supreme Court. They just abdicated their responsibility to address this issue and to address the technology behind it. So that leaves innovative entrepreneurs like yourself saying, okay, I have a solution for this. Now, what's the end game of generated pictorials? I think Sabi's right. They've invested billions into this, and they're going to start litigating this left, right, and center. But if I'm giving advice to companies like yours, I'm going to say, let them fight that one out. That's a battle of the titans. They said, what you need to do is say to the companies here, I'm not going to generate, I could save you a ton of money and a ton of time, and I could turn this around in 24 hours if I can generate, but I can't generate now because the Supreme Court has abdicated its responsibilities. The GDPR clearly has extraterritorial jurisdictions on this, and at the end of the day, here's my solution. I'm going to come down to your firm. I'm going to take a lot of pictures. I'm going to get some waivers. I'll do some I'll do demos there. I will do seminars there, and everyone's going to agree that I can use this on further development, but it's going to be confined to your business model. And the sad fact of the matter is every business is going to have to do that if they want to avoid this litigation until the Supreme Court finds the courage and the capability of well, I don't want, it's a little unfair, I guess, to say the courage, but it's certainly the capability of addressing this issue. And I think they will eventually have to redress the issue once. What does Anthropic do? Because then you're going to say, well, why am I going into your pro level? Because all you're really doing for me is something I could probably do. You're touching up my photos. These are my photos, my photographs. I own these. And why should I run anything through you? And I really, to be honest with you, it's a little fun to take a picture of somebody and put them in a cartoon, but I'm not spending pro level fees on that. So
especially if I don't own, after doing it, I don't own it. Why would I then pay you to do it?
Why would
exactly. Yeah, exactly.
Might as well do it myself, and I'll own it. And I'll own it, and I'll control it. And I think that's the that's a, now again, if you're a Thinkland company and you got that artistic background and you're able to take photographs, that's going to be really good, because I've seen what you guys have done with the basic cell phone pictures. So the question really comes down to is, here's the thing: if I want to avoid the EU AI completely, I'm just not going to use AI for anything. And that's what AI is going to have to deal with. I said, why should I do that? Because I don't want to do, it looks like there's going to be more value on me taking my own photos and then putting them through, I'm building out my GCC and have my editing team, work around the clock on that. And, because I'm not going to get anything I can use or my clients can use. And more importantly, I might be putting my clients at risk if one of those generated pictures runs afoul with GDPR.
I mean, as a developer, you definitely got to question all of this stuff. I mean, you got to maybe take a step back and really look at this thing, because, and I appreciate it, Jerry. I mean, definitely reach out to my team at Thinkland. Go to thinkland.com, because I mean, as you can tell, we're clearly trying to navigate this thing and understand what the best thing it is to do for people that are in the AI space and looking to develop and start their startup. And right now, I think this is a necessary conversation to have about who actually controls AI. And I think right now, I mean, people in this conversation, people that are following this conversation, that continue to follow this conversation about, what they talk about it as if AI is this tech race, but really it's coming down to a rules race. What are the rules? And there's clearly got to be a lot of litigation, and it seems to me that the U.S. is dragging their feet right now. So you have the GDPR that is basically making the law of the land right now. So while everyone's focused on who has the smartest model, someone else is deciding what those models are even allowed to do. And so, really, to be honest, in this AI era, power isn't just coming from building the system. It really is coming from who's writing the rules and who has to follow them. And I think, please definitely continue to follow this, because we're going to be following this. We're going to continue to be discussing this on MGSN.net and all our partners. And I just, again, thank you guys for coming on, because I think this was a really important discussion. And honestly, it's going to have major repercussions where it stands now. And, like we all just said, if you're a developer right now, you're saying, well, why would I even use this thing? This thing that I saw so much value in, I'm questioning now the legality and my ownership on all of it. So, for people that are clearly in this space, and I think right now AI is in every space, thank you for following, and we'll continue to cover this. And as always, guys, we'll see you all next week, and appreciate all of your support.
Thank you. Thanks.
Thank you. All right, guys. Enjoy the evening over there in Pune, Sabi. I wish I was there. It seems it's my kind of weather. Mac, welcome back to New Jack City.
It's good to be back in New York.
Yeah.
Thank you, my friends.
Great picture of Ryan Park behind you. Enjoy this nice spring weather here. All right, guys.